Many people have asked me about police interviews and the caution and whether evidence is admissible if you haven't been cautioned and what amounts to an interview. So I'm going to run very quickly through some of these answers and then you can ask your questions and I can come back in more detail on any of them. So the idea of an interview in the first place is for officers, which I'll come back to in a moment, to ask questions of a suspect about their involvement or suspected involvement in an offence or alleged offence. And the reason for the caution is so that the suspect knows that they have a right to silence and that anything that they say might be used in evidence and that there will be an adverse inference drawn if they remain silent, in other words, refuse to answer questions at the earliest or most reasonable opportunity to answer those questions or to provide an explanation and information that might serve in their defence. All of that summed up neatly in the caution, which is you do not have to say anything, but it may harm your defence if you do not mention when questioned something you later rely on in court. Anything you do say may be given in evidence. So very briefly, what is an interview? Well, this could be simply one question, and it doesn't need to be formal, sitting down in the police station. It could happen anywhere else, in fact. And one question, if it relates to a suspect's involvement or suspected involvement in an offence or alleged offence, then that's likely to amount to an interview, if it goes beyond just establishing their name and identity or whether a vehicle belongs to them or something like that. And so just to reiterate, it can be formal or informal. So if the police are inviting you to a voluntary interview, don't think that this is any different from any other kind of interview. It might seem a little bit less formal, they might dress it up a little bit less formally, but it will still have the same ramifications as a normal interview. It will still require the same caution and it will still have the same effect as though you were arrested, detained and interviewed, because the questions put to you will be put for the same purpose and any answers you will give them will be treated in exactly the same way. Thus we come on to the caution. The reason for the caution, as I've said, is to inform the suspect of their right to silence, their right to free legal advice, their right to inspect the PACE codes and various other things. And if this caution isn't given to the suspect and matters do go to court, then their defence representatives can make an application under the Police and Criminal Evidence Act, section 78, that is to exclude evidence that might be unfair, such as an interview where the defendant wasn't cautioned. Section 78 of PACE, as it's commonly known, for the exclusion of unfair evidence reads, in any proceedings the court may refuse to allow evidence on which the prosecution proposes to rely to be given if it appears to the court that, having regard to all the circumstances, including the circumstances in which the evidence was obtained, remember the way it was obtained during interview, under caution or not under caution, or worse, under oppression. Let's read on. The admission of the evidence would have such an adverse effect on the fairness of the proceedings that the court ought not to admit it. So in plain English, what that means is if you have been interviewed but you haven't been cautioned, or much worse, if you've been interviewed and threatened at the same time, then your defence representatives can make an application under section 78 of PACE. It's known as a section 78 application to exclude that as evidence even before it gets to a jury. But it's one of these areas where the court has the discretion. It's not a must. Under this section, the court may refuse to allow evidence if, having given regard to all the circumstances and how that evidence was obtained, it would have such an adverse effect on the fairness of the proceedings. In other words, it would make the proceedings unfair, that the court ought not to admit it. Now, dealing very briefly with companies, let's say we have a sole director of a company, so it's the only person in charge of the company, but the company, as they can be, is being prosecuted for a criminal offence, and the police want to question the director about the company's involvement in that offence. They should make absolutely clear that there are two separate interviews, one on behalf of the company and one on behalf of the director as an individual. Otherwise, it will be impossible to determine which bit of evidence was being given on behalf of the company and which bit of evidence was given on behalf of the individual director, him or herself. So there should be two separate interviews, both under caution, and quite clearly distinguishing which legal entity is being questioned. And finally, I said I would come back to officers. That's because it isn't just police that can interview under caution. It could be HMRC, it could be DWP, it could be the Serious Fraud Office, it could be the Health and Safety Executive, the Environment Agency, the Department for the Environment, Food and Rural Affairs, or even the Insolvency Service, just to name a few. So I hope that serves to answer a few questions about police interviews and cautions. Obviously, I won't have covered everything. It's impossible to have covered everything, but please do leave questions down below. I will come back to them, so make sure you subscribe to receive those. Like this video if you do like this rapid fire content, and of course, thank you for watching.